Can you see me, Mr. Burrell?
Yes, sir. We're good.
Okay, right.
There'll be a quick introduction and you guys can start.
Okay.
Hello, I'm Chris Burrell, President of the Magic City Bar Association. Thank you so much for joining us for this final installment of our social distancing CLE series. This has been a great year for the Magic City Bar, and it's all because of committed members just like you. At the conclusion of the CLE, be sure to do 3 things. First, submit feedback so you can get credit for attending the CLE. Second, renew your membership. Third, send an email to 5 friends asking them to join or renew as well. Lastly, be sure to join us for our annual meeting later this afternoon so you can be in the know about what's going on with your organization. We will now turn it over to our CLE presenters. Happy holidays.
Well, good afternoon, everyone. I hope everyone is doing well, and I'm glad to be here. I want to start this off by thanking President Chris Burrell for the fantastic job that he is doing with the Magic City Bar. He is doing an outstanding job. So I congratulate you, sir. I also want to thank my cohort, Judge Tamara Harris-Johnson, for joining me with this CLE, and I appreciate her presence. She is one of the greatest intellects I've ever known. I'm slightly intimidated by being here with her, but I certainly am honored. So thank you all for having us. Judge Johnson, I'll go ahead and introduce myself. I'm Judge Michael Streety. I'm the divisional presiding judge of the Circuit Criminal Court here in the Birmingham Division of Jefferson County. I was elected to the bench in November of 2016. I took the bench in January of 2017. I have a long history in the criminal justice system. I started back in 1996 as a deputy sheriff, worked for 5.5 years as a deputy sheriff, went on to become a state probation and parole officer, and then became a prosecutor for 13 years before being elected to the bench. I'm glad to be here, and I'm going to try and talk about some issues that are prevalent or in circuit court and give you some insight of what the judges think from behind the circuit court bench. Judge Johnson? Hello? I don't know. I don't know if Judge Johnson is on with us. I thought she was, but I guess I'll go ahead.
I am here. Can you hear
hey,
me?
Judge.
Oh, hi. No, I am. But I was muted. Well, good morning. My name is Judge Tamara Harris-Johnson, and I serve as a circuit court judge on the Civil Circuit Court in Jefferson County. I too want to thank the Magic City Bar Association and Chris Burrell, and I am also in awe of my co-panelist, Judge Michael Streety. It's my pleasure to be here to talk to you. I'll just briefly introduce myself as well. I passed my first bar in 1978, and that was in the District of Columbia. I'm a member of 4 bars by examination, and that's DC, Michigan, California, and Alabama. After clerking for a Superior Court judge in the district, I began my law practice, and I was the first African-American and the first female to serve as a labor union attorney for the International Brotherhood of Police Officers and the National Association of Government Employees. I was a prosecutor in Los Angeles and here in Jefferson County, and I also was a criminal defense attorney in Los Angeles and in Alabama. I was a trial attorney for the EEOC, and when in private practice, I worked for a firm. I also represented corporations who were accused of unlawful employment practices. I was the first female city attorney for the city of Birmingham, and I served as a bar examiner for the state of Alabama from 2000 to 2004. I taught basic skills in trial advocacy at Cumberland School of Law, and I've been the national legal advisor for several international organizations, Jack and Jill of America, the Links Incorporated. So in calculating my trials before taking the bench, I probably had tried conservatively about 600 jury trials. And I can tell you that my practice has been very, very balanced on both sides of the spectrum. So it is indeed my pleasure to be a judge, to serve you, and to be here today to talk about issues that arise in my court and how we can deal with them. Hello?
So I guess I'll start. That was me. That was my fault, Judge. I was muted. I guess I'll start off by, with the Circuit Criminal Court and sort of give you some insight as to where I'll try and go with this CLE presentation. And I'll talk about, and basically what I'm going to try and do is the case from pre-indictment to final adjudication. And then what I want to focus on is when the case makes the transition from district court to circuit court. And I want to talk about some objectives that I plan to deal with to provide helpful information that will assist lawyers in dealing with criminal cases after district court to final adjudication, sort of to refresh your recollection on laws and rules often pushed to the back of our minds after we practice for a while, and to prepare you to be prepared. And I think that is essential. I'm going to try and deal with issues such as integrity, protect your reputation in the court. Your reputation is all that you have in this business, and you all know that. I want to talk about jurisdiction and deal with some issues. The ball is now in circuit court. I want to talk about the arraignment, the necessity of that particular procedure. I also want to talk about the plea of not guilty by mental disease or defect, Rule 11. And I'm going to briefly hit on all these particular topics and try and go, like I said, from district court, from when the case starts in circuit court to final adjudication, and give you some tips and hints. Preparation for pretrial conferences, being prepared. Plea negotiations, what is the court's role in that? Also talk about guilty pleas, protecting yourself, getting it on the record. Also pretrial motion hearings, predetermination of legal issues before the trial starts. And I think that's very important. Also your preparation for trial, in particular, preparing witnesses to testify. Just some insight on what I've observed and what I think will help you in trying your cases. Also trial issues, preserved issues for appeal, and also post-trial issues. And I want to say this right here. You know, I don't think there's been a more difficult time to be a trial lawyer in this new age of COVID. And we're certainly doing the best that we can in circuit court to make sure that we move forward and looking forward to trying cases. Quite frankly, I have not tried a jury trial since I think January of this year. I have had one bench trial, and of course, you know, lawyers have to elect to have a bench trial. But these are the issues that I plan to cover, and Judge Johnson and I will go back and forth and sort of delve into these issues and hopefully offer you some great insight. Judge Johnson?
Yes, and I too, from my experiences, I want to emphasize that each judge is different and the procedures that they do may be different. So it's really important that you as a trial attorney understand and know the judge and the judge's idiosyncrasies. I mean, some are sticklers for being on time. Some move their cases very quickly, some don't. But you need to know which ones do, which ones don't. You need to know your rules, and you need to know what you can and cannot do. You need to know your judge. And as I said, you need to know the idiosyncrasies. You have to be professional because how it looks matters. The little cutesy stuff doesn't always go across well. And in other words, you need to vigorously fight for your client, but you need to honor the rules of engagement and know, what you can and cannot do. So Judge Streety, do you want to start and, or then I can just start because I want to go through, just like you talked about, but on the civil side, I want to deal with the complaints, why it's important to format your complaint, to have your complaint as perfect as you possibly can, even though amendments are allowed, dealing with the cut and paste issues, the scheduling issues, mediations, when they are appropriate, when they aren't, specially set cases, talk a little bit about jury selection, and the jury trial, when you cite cases, attorneys making objections, default judgments and attorney's fees, collection cases. Now that's a big bugaboo in my court. So I do want to talk about collection cases. And I do want to just briefly mention and encourage every trial lawyer or every lawyer period to read the Alabama Legal Services Liability Act, which is cited in Title VI of the Alabama Code, from Title 6-5-570 to 65581, because I do believe that it's very, very important for you as practicing attorneys to know what rules apply to you and what you need to do to be in compliance with those rules. Because I have seen a few cases that have come through my court that do allege legal malpractice as well as the medical malpractice. And there's a specific statute that deals with that as well. So I'll turn it back over to you, Judge Streety, and you can begin and then I can chime in or however you want to handle it.
Yes, ma'am. I want to talk about something that I know is near and dear to you also, Judge Johnson. That's the first issue. People often say that people remember the first thing you say and the last thing that you say, and that's very applicable. So I want to talk about the issue first. The number one issue I think that is important for lawyers is integrity. And I want to move to slide 4 in my presentation, if you don't mind. Slide 4, and it talks about the rules of professional conduct, 3.3, candor towards the tribunal. And A1 says, a lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. And listen, integrity for a lawyer is everything. Without your integrity in this process, you have nothing. I've been in situations where lawyers have not necessarily made a false statement, but by omission allowed the court to perceive something that was not necessarily fact. In particular, often I deal with bond hearings where a lawyer will file a motion to set a bond for their client, and the court has a certain idea of what the issues are and what's going on with the defendant, and not have other facts that are relevant to the court's decision in bond. If the lawyer perceives that the judge has one perception of the facts and the lawyer has an idea that something else is true, it is incumbent upon that particular lawyer to inform the court so the court can have the proper information to make the necessary decision in any type of decision that the court makes, particularly in the bond situation. So I want to make sure that that is the first thing that I say, and hopefully that you all remember that. Like I said, without a lawyer's integrity in this process, he has nothing. And I'm sure Judge Johnson wants to chime in on that.
Yes, and I too cannot emphasize enough about the integrity, because every lawyer that comes before me is an officer of the court, and I'm going to treat you as such. I'm going to believe what you tell me until you prove to me that I cannot believe what you tell me, and then that's not going to be very good. And just let me give you just a brief example of how that became so prevalent with me. When I was in Los Angeles and I worked for the city attorney's office there, we did jury trials, and there was a case that I had to try, and we had the speedy trial statute, and I was assigned to a trial court. So when people would come into the master calendar court, they had to announce either they were ready or not. So and if they were ready, they got sent to the trial court. The first time I saw a case was when the jurors, the witnesses, the file, everything was coming to my court. So it was truly a trial by fire. And I got a case. It was a woman who was alleged to have committed prostitution. It was her 6th time. She was going to, if she was convicted, she was going to get 6 months non-probated. She came in, they had announced ready, and she decided to plead to the case. I don't know why. As she was filling out the paperwork, I got a call from the police department that said that they misspoke because the officer who had made the arrest was on vacation. So we really were not ready. She had not finished filling out the paperwork. I went over to her, took the paperwork, ripped it up, and I said, "This is your lucky day." And the judge was livid with me because she said she was getting ready to plea. I said, "But I had an obligation, as an officer of the court, not to misrepresent something to her." Unbeknownst to me, the defense attorney went back to, because it was public defender, went back to the public defender's office, told everybody there, and I kid you not, whenever I gave an offer on a case, I never got challenged because my reputation had traveled through the public defender's office that I don't misrepresent. I'm not going to lie. I'm not going to take advantage of your client, but I am going to fight like the Dickens, if you take me to trial. So your integrity is what is your lifeline. That's how you get clients. That's how you get respect from the jurors, and they can see it. You can see it. That's how you get respect from other attorneys who work with you. So Judge Streety is absolutely right. Integrity is the foremost thing. And judges, they look at attorneys, when they come before them, and they want to know, are you telling me the truth? Because the truth of the matter is nobody was there except for the actual parties as to what happened. Nobody knows what they know better. But what is the worst thing to do is to intentionally or negligently misrepresent a fact to the judge that is really critical to the disposition of the case.
Excellent. Well, I'm going to go ahead and move on to slide number 6, and I'm going to talk about the district court, the criminal case when it leaves district court and makes its way to the grand jury. Oftentimes, the grand jury is considered the dead zone where nothing happens with your case. So my case has been bound over or waived to the grand jury. Now what? Then I'll go to the next slide. Well, just because your case is on the grand jury does not mean that the case is necessarily stagnant. Oftentimes issues develop when a case is on grand juries, and lawyers have to address certain issues with bond, or even mental health issues have to be addressed while the case is pending grand jury. So let me move on to slide number 7, I believe. I'll try and clarify when a circuit judge can act on a district court case. I'll also answer a few other questions that come up when a district court criminal case makes its way to the grand jury. Can a circuit court judge handle a case pending before a district court judge? When does the circuit judge acquire jurisdiction to handle district court cases? And let me say this right here. I apologize if some of this stuff is elementary, but I've dealt with issues in the recent past where these issues had to be addressed, sometimes with lawyers who've been practicing for a while. Like I said, once you practice for a while, sometimes these issues sort of go to the back of the burner. I'll also answer the question, when a circuit judge should, what circuit judge should you approach in dealing with your client's case after the case is waived or bound over to the grand jury? After the case is waived or bound over to the grand jury, can you go back to the district court judge to deal with the case as it's pending grand jury? So let's move on to slide number 9. Let's talk about the basic jurisdiction of district court first. And let's clarify this. The general rule is that jurisdiction of a case can be in only one court at a time. And I think that's applicable to this situation. In slide number 10, let's go to section 1232, criminal jurisdiction generally on felonies dealing with district court. The district court may exercise original jurisdiction concurrent with the circuit court to receive pleas of guilty in prosecutions of offenses defined by law as felonies not punishable by the sentence of death. In slide number 11, the district court shall have jurisdiction to hold preliminary hearings and prosecutions for felonies. And this is important as provided by, in Title 15. And I want to go over some issues that develop as it relates to that. Section 15:11(2) says that the district court shall exercise exclusive jurisdiction to hold preliminary hearings and prosecution of felonies. Some of you who practice over here in the criminal courts in Birmingham know that until sometime recently, murder cases and capital murder cases were going directly to circuit court. Well, that would seem contrary to what the law says. The presiding judge of the circuit, Elizabeth French, she basically designated circuit court judges as special district court judges to handle district court cases and deal with preliminary hearings. And that's how we were able to get the jurisdiction to handle cases as they were pending in district court. And we could only do that by Judge French designating us as special district court judges. So when can the judge act on a district court case? When can the circuit court judge act on a district court case after the case is bound over or way to the grand jury? Well, there's a rule that clarifies that, and that is Rule 5.4 in the Alabama Rules of Criminal Procedure. And it talks about the transmittal of records. And it says this, transmittal of records within 14 days after waiver or conclusion of the preliminary hearing, all original papers and records shall be transmitted to the circuit court. If you can recall a situation where you've handled a case and you've gone to the district court judge and the judge said, well, I don't have jurisdiction to hear your case for a bond hearing. That is because this law has taken effect and the case has been transferred to circuit court. And this particular rule gives the circuit court jurisdiction to handle your case and hear bond hearings. So it's important for lawyers to understand when the circuit court judge can act on a situation in a case after that case has been bound over or waived to the grand jury. And that particular rule gives the court the authority or jurisdiction to act on the case going to circuit court. Anyway, I'll stop right there and turn it over to Judge Johnson. I know time is going to try and get away from us quickly, and I'll try and be aware of that. Go ahead, Judge Johnson.
Okay, I'll talk about complaints. Just very briefly, when you do a complaint, I mean, the Rules of Civil Procedure, Rule 10B, really tells you the format for using the complaint. And it's very, very helpful, not only to the plaintiff's attorney, but to the defense attorney and particularly the judge. And what it says is you number your allegations in the complaint, and each numbered item in the complaint really should have one particular allegation of fact, so that when the defense is looking at it, they can look at it and they admit or deny. When a complaint has multiple facts contained within one paragraph, it's very difficult for the defense attorney to admit or deny, because if they just say admit or deny, or they admit in the entire paragraph, because it can be legally, be determined to be so. So it could be problematic. In addition, when people are doing, or when the attorneys are getting their complaints or their pleadings together, a lot of times we cut and paste. And I understand that because it saves time, and sometimes some of the language that you use is repetitive. However, if you're not a good proofreader of your own work, get someone in your office to do it, because what you don't want is for the first thing that the judge sees when they're looking at the complaint to see the complaint is John Doe versus Mary Smith. And then later in the body of the complaint, you're talking about Hal Thompson and Gene Jones. So you want to make sure that the complaint is in as perfect a condition as possible, with the understanding that you can amend the complaint. And usually that comes in when you're talking about, after you have done some discovery. Now, when you have your complaint, if it's laid out in the way when you number the paragraphs, it really helps you, because on the plaintiff's side, you have certain elements that you have to prove. And when you're laying out your allegations, it's really more of the roadmap for you to say, well, wait a minute, I'm missing this element in this charge. I need to address that. And you put that in there because we have The complaints, defense attorneys will file motions to dismiss. And those of you who practice in the civil court know that if you file a motion to dismiss, you don't have to answer first, because the motion to dismiss will take priority over the answer. And in filing the motion to dismiss, it really deals with the four corners of the complaint. But within the four corners of the complaint, the burden is very, very high on the judge, because it's beyond, the judge has a burden of beyond a doubt that the plaintiff cannot prove any charge that's contained within that complaint, pursuant to the motion to dismiss that's been filed by the defense. So, and if there's anything that's additionally alleged with regards to the motion to dismiss by the defendant, then that puts it in another category, and it will shoot it over to possibly a motion for summary judgment. And the burden is really different there, because all you need, it just doesn't have to have a genuine issue of material fact, for that to be granted. As long as there is a genuine issue of material fact, the motion for summary judgment will be denied. So you deal with that. And so I've dealt with the concept of the complaint and how important that is. And so I'm going to turn it back over to Judge Streety. And when I come back, I'll talk about scheduling orders, mediations, specially set cases, things like that. Judge Streety?
Okay, I'll briefly talk about the arraignment and the pretrial conference next in order to move the case along through circuit court. Well, let's go to Rule 14, and that's on slide 16. Understanding the necessity of your client entering an appropriate and timely plea at the arraignment is very, very important. In slide 17, no defendant shall be tried for the commission of any misdemeanor or felony unless he has been arraigned in open court. This particular situation is very important for the circuit court judge. Basically, in particular in capital murder cases, if a defendant is not properly arraigned, then that case then all sorts of problems can happen, even if there's conviction that is had in that particular case. I've seen Rule 32s that have been filed where a defendant had not been properly arraigned, and that case was sent back to the court or even reversed for that particular reason. So it's necessary that the defendant is properly arraigned, except in slide number 18, an arraignment need not be held if defendant through counsel has filed a written waiver of arraignment and plea. And that waiver must be signed by the defendant and the attorney, stating the age and date of birth of the defendant, acknowledging receipt or copy of the charge. Also, a copy of the plea and waiver must be served on the prosecutor, okay? Now, the pretrial conference. The pretrial conference is important, and it's important for this reason. Oftentimes when I hold pretrial conferences, lawyers will show up, and this is the next thing. Judge, well, we need a new date for the pretrial conference. And I always ask why. And the reason is given as this: we haven't had time to talk with the defendant. We haven't had time to talk with the prosecution. We haven't had time to confer, if there's a co-defendant, with his lawyer. Listen, at the pretrial conference, the next stage should be setting the case for trial. So it's very, very important for lawyers to understand this. Prior to the pretrial conference, it's absolutely necessary that they communicate with their client, communicate with the prosecutor, also communicate with the co-defendant's counsel if that is appropriate given the circumstances. Okay. All offers must be relayed to the defendant at the pre-trial conference. I mentioned Rule 32s before. Oftentimes when I get a Rule 32, the first thing that is filed or is alleged is ineffective assistance of counsel, where the defendant claims that he was not properly informed of an offer made by the state. It's very important, and I often do this. I make sure at the pretrial conference that I get offers on record to make sure the defendant is aware of what the offer is. Also, this is another thing that comes up that needs to be addressed at the pretrial conference. It is untimely to request discovery at the pretrial conference. Discovery should happen prior to the pretrial conference, because basically, if you don't have discovery, then you can't even move your case forward. How can you properly inform your client as to what his situation is if if you do not have discovery. And the pretrial conference is to move the case forward. So those are some things that should be addressed prior to the pretrial conference. And I always tell lawyers this: listen, if you have an issue getting discovery, you can involve me. You can involve the circuit court. The circuit court judge is more than willing to step in if lawyers are having issues with discovery. The court will hold a hearing relative to discovery, even prior to the pretrial conference, if that is a problem. Like I said, the case needs to move forward after the pretrial conference. The court hates to keep setting pretrial conference after pretrial conference. That case becomes stagnant. And I'll tell lawyers this, defense lawyers, you have a client, and the client is your defendant. The state, you represent the state and the victim. Well, the court's client is the docket. We are very, very concerned about moving our dockets and making sure that the docket is not stagnant. So the pre-trial conference is set to move the case forward, okay? And I'll go into plea negotiations next, subsequent to Judge Johnson. Go ahead, Judge Johnson, I'm sorry.
No, thank you. I'm going to deal with scheduling orders. Because I have practiced for such a long time, I understand how hectic it can be to juggle cases and to juggle your schedule. So a lot of the judges, most of the judges actually, have their own scheduling orders, and they, fill in the dates for cases. I don't do that. I allow the parties to file proposed scheduling orders. I will get the trial date. I'll give you a trial date. If the case is set for mediation, I'll give you a mediation no later than. And I will allow the parties, the counsel for the parties, to get together and give us the dates. Give me a proposed scheduling order, because you know your schedule better than I do. I'm not going to try to dictate to you when you need to get this done, when you need to get that done. As long as the two of you, or however many there are, if you can work professionally and you can agree on certain dates, that's fine. If you can't, then of course I will come in and I will impose a date on you. Now, having said that, if there are certain dates that you have agreed upon, and when it's time for you to, deal with your discovery, to submit discovery, and sometimes attorneys want to play games. They want to be cute and they don't want to give over the discovery that they want, or then they throw in just a bucket list of objections that really are not applicable. So then we have, several attempts to get discovery, then it's a motion to compel. And then we go through it, and then everybody is saying, oh, well, I didn't know that's what you meant. That doesn't really sit well with me. I did have another case when I first got, I had been on the bench maybe a little over a year. And this case had been lingering. And one of the attorneys had just dragged the case out for a very, very long time. Then he filed a lot of delay motions on plaintiff's counsel. And in those motions, he was accusing them of committing felonies, that they had forged certain documents and all. And the case, the motions, underlying motions had already been ruled on by my predecessor. But because there were these allegations of some kind of criminal activity, I felt an obligation to open it back up to review that. I had a hearing on it. It was absolutely a waste of everybody's time. There was no evidence at all of any kind of criminal activity, but the plaintiff's attorney, they brought in witnesses. We had a court reporter. We went through just volumes and volumes of paperwork. And what I did, I sanctioned the defense attorney for that frivolous motion, because what he did by accusing another attorney of committing a criminal act, conceivably could have done something to affect that attorney's license or anything, and he had absolutely nothing to substantiate it. And so I sanctioned him $35,000 that he had to pay to opposing counsel. I probably sanctioned about 3 different attorneys in the sums of about $35,000 when they have made really frivolous motions against opposing counsel. And it's been a waste of the court's time, and all they've been doing is trying to prolong a case. If you need time, if you need a continuance, you can ask me. I'm going to grant it if it is not unreasonable, but I do not take kindly to any attorney accusing another attorney of something that is totally improper if they have nothing to base it on. I do send a few cases, quite a few cases to mediations, particularly with COVID, because as you can imagine, we have suspended a lot of jury trials, or suspended all of the jury trials. And I'm speaking quickly so that I can get everything in within the time frame. And mediations work. Mediations, at least if they're not successful in resolving the case, they can bring to the attention of counsel for both parties their weaknesses and their strengths in the case, and it's better, and they're then better able to try to resolve the case. And with COVID, and the cases are backing up schedule-wise, I think if you want a resolution of something sooner as opposed to later, mediation is something that you probably should consider. I have specially set certain cases, for instance, medical mal cases, or cases that are involving FELA, asbestos kinds of cases where there are a lot of expert witnesses. They are coming from out of town. I don't want to put a burden on either counsel to have to pay for the travel expenses for a case to maybe go, maybe not. So I will specially set cases if they're anticipated that cases will take more than a week. I will usually look at, well, I say usually, but I look at the dockets, and I will get a trial week for the first week, but it usually falls into a non-jury week for the second week, and that will take care of that. Status conferences, when status conferences generally take maybe 3 to 5 minutes max. I try to stagger status conferences. For instance, some attorneys, collection attorneys, for instance, may handle several cases in the court at the same day. So I try to look at that as best I can and schedule them all at the same time so they're not running back and forth, to my court, to somebody else's court all day long. I also try to give you a time limit. I didn't like it when I was practicing law to sit out in the courtroom and just look, and there are nothing but people. So I try to at least give you some kind of appointment, reasonable appointment to come in for a status conference. If you are out of the county, if you are out of town, you cannot make it to court, I will allow a telephonic status conference. And I was allowing a telephonic status conference even before COVID hit, because there were people, when I saw, sometimes attorneys would come in and they were driving from Mobile to be in here for 2 to 3 minutes on a status. And I said, why didn't you just call? Because all you have to do is call, because on a status, all I want to know is, where are you? Are you ready to go? When will you be ready to go? And that can really be handled very quickly. So, but if you're here in the city, in Jefferson County, then yes, I would like to see your face, but it can be done if there are situations that come about. I'll turn it back over to Judge Streety, because I'm about to go into the jury part of my presentation.
Okay, well, thank you, Judge.
Okay. Mm-hmm.
I find myself also speaking quickly because I'm trying to get through, and this hour is going by pretty quickly, okay? I'll start by talking about plea negotiations, I guess, guilty pleas. I want to ask lawyers to make sure that they understand that when they talk to their clients that the court is not a party to the plea agreement, okay? And that needs to be clear to the client, because oftentimes when a defendant enters a guilty plea and goes off to the penitentiary, perhaps he'll send me back a letter, asking me to modify the plea agreement, which I rarely do, okay? But I want to move into something else and talk about blind pleas for a moment. The worst thing a lawyer can do is guarantee to their client what the judge will do with a blind plea. That is the worst thing to do. Unless, and there's an exception to that, if the court confers with the prosecution and the defense, and the court lets them know straightforwardly what will do, that is the only way I think that lawyers can say to their client that the judge if you entered a blind plea. Without a judge being specific to that, those lawyers should tell their defendant or their client that the judge is going to do this, or you're going to get this sentence. That is right for the plea to be withdrawn. and the basis for a Rule 32. So I want to move quickly into pretrial motions and talk about evidentiary issues. All evidentiary issues should be resolved prior to trial. The court's decision in these matters is usually definitive and final unless facts come to light that were not known by the court at the time it made that decision. And the reason I bring this up is for this reason. Basically, oftentimes when we get into trial, these issues come up with evidence, and the court has to make a decision on the spot about the evidence. Well, these issues should be decided pre-trial, but because the court is not privy to the facts of the case, the court does not know all of the issues in a case, all of the evidentiary issues. Those issues have to be raised in pre-trial motions. And it is incumbent upon the defense and the prosecution to bring those issues to the court. It is improper to make an objection during trial relative to an evidentiary issue and start talking about that issue if the court has not made a definitive decision on it. And if the court has made a definitive issue on it, those issues should not be rehashed in front of the jury. That's very, very important. So pretrial motions are a necessity in order to deal with evidentiary issues. And it's incumbent upon the defense and the prosecution to bring those issues to the court, again, because the court does not know the facts of the case and cannot discern all of the evidentiary issues because the court is absent of the facts. Anyway, Judge Johnson.
Okay, let's go to jury selection. Generally, I have, in my jury selection, I'll have 14 jurors, 2 alternates. Nobody knows who the alternates are until after all of the evidence has been presented. The case is about to go back into the jury room for them to deliberate. And I'll have someone from the plaintiff's side, someone from the defendant's side, and I have a very scientific method of choosing the alternates. I put all of the names in a bowl, and I have a party from each side pick a name. Those are the alternates. I've had some say that they have not had it done that way, but they like it because everybody pays attention. The alternates don't know that they're going to be, I don't even know who's the alternate until they're chosen at the last minute. So everybody has, is in full attention. Now, during the jury trial, there are certain things that I have noticed about attorneys, and sometimes it's with the younger attorneys or the ones who've just been newly practicing, but it could happen to olders. Don't be so wedded to your script. I mean, I know you have an idea of what you want to tell the jurors, but you're going to need to go with the flow, because the witnesses who take the stand, they're not getting ready to be wedded to a script. They will change, they will surprise you, they will come up with things that they may not have told you before, and you're going to have to be able to adjust and adapt with it. You're also going to have to be able to, how do I want to put it? Talk to your clients about their expectations. You've got to sort of measure their expectations, because sometimes when they come into the trial, they're wanting a lot of money. The plaintiffs are, they're thinking that they were damaged or they were injured, and they have this really an enormous amount of money that they think they're going to get. And as they are testifying, as other people are testifying, I'm looking at this case like you'll be doing well if you can, pay your attorney's fees when you get out of here. But you need to be able to adjust and control your client's expectations and adjust as well. Don't try to be cutesy when you're in there trying a case, because the jurors, I watch them and they don't like it. I don't particularly like it either, but they don't like it. And watch the jurors. Don't just keep looking at your paper or whatever. Watch the jurors, get some kind of eye contact, because you'd be surprised at what the body language will tell you about whether they're with you or whether they're not with you. When you are arguing cases and you're citing cases to me, don't think that you're just going to give me a case and I'm not going to read it. I had a medical mal case, and around 9:30 in the morning, both sides gave me a whole lot of cases. And they thought that I was just going to rule right then and there. I took a break until afternoon. I bought pizza for everybody, and I said, I'm going to read each and every one of these cases. And when I read the cases, some of them were on point, A lot of them weren't. Some of them were in the ballpark, but were not necessarily playing football when they were playing basketball. And I'm using those really as sort of analogies. So when you're going to cite a case to the court, make sure that the case is applicable to the facts that are being tried, because it's a waste of everybody's time. Objections. When attorneys make objections, I pay very close attention to the objections, but this is one that I've heard. So I think I've heard repeatedly. So I think it's important enough for me to at least mention it. When there's an objection, I have had attorneys tell me, nobody else has ever stopped me from doing that. Nobody else has ever, made me do that or not allowed me to do that. Until such time as you can bring me a case or show me in anybody's evidence book where that is a valid objection, I don't want to hear it because it doesn't make sense. I don't care what anybody else does or doesn't do. I am interested in the valid objections that are recognizable in a court of law. Default judgments. There are times when, obviously, when people are sued and they don't respond. Well, with COVID, I've given time, and I generally will give time, even though they have to respond within 30 days of an answer. I will generally give a little more time, and I will issue an order and will say that I'm going to give you until such and such a date to file an answer, because even in the rules, a default judgment can be overturned if an answer is subsequently filed. I mean, a lot of it's in the discretion of the judge, but the main reason for a default judgment is that nobody even bothered to respond in the first place. Attorney's fees. Now that one is interesting here. I have had several default judgments where attorneys have put in for their attorney's fees. When you look at the contract, it asks for reasonable attorney's fees when the attorneys have signed on to collect the money. Then they will turn in exorbitant attorney's fees, sometimes like a third of the amount. Now, I will generally ask for, give me your an invoice. I want to know how much time you spent, what's your billable rate. And sometimes, even though the amount may be small, if you've put in that amount of time legitimately, okay, I can see that as being reasonable. But if, let's say, the amount is, because I've had this happen, the amount is $100,000 just for a collection. You've put in about 5 hours for the work, and then you turn in an affidavit from a co-attorney that says a third of that is reasonable. That's just an opinion. It's not reasonable until you show me the amount of time you put in, your billable rate, and your invoice, so that I can determine what is in fact reasonable. I think that it's very important when we are dealing with people, particularly, and I'm saying particularly with COVID, but I deal with people all the time, because sometimes I've had, people come up to me and say, well, tell me this, are you a plaintiff's judge or are you a defendant's judge? I said, I'm a judge who follows the law, factored into where the facts lead me, and I fall wherever they take me. So on one case, you may think I'm plaintiff. On another case, you may think I'm defendant, but I'm fact and law driven. Anyway, I'm going to stop right there and give it back to Judge Streety. And I do want to tell you before, because Judge Streety may take up the remainder of this time, because I know we're going to have questions. I want to encourage everybody to please familiarize yourself with the Alabama Legal Services Liability Act. That is the act that governs whether or not you can be sued for malpractice, and tells you what you can do, what you can't do, your statute of limitations. It applies only to lawyers licensed to practice law in the state of Alabama. It is well worth the time and effort for you to read it. Judge Streety.
Well, thank you, Judge Johnson. I want to offer a few trial tips as it relates to voir dire, opening statements, objections, preserving an issue for appeal, and closing arguments, and I'll be very brief. I just want to simply say, and I apologize if this stuff sounds elementary. It helps me as a judge to sort of go back over things that I've known for years. In voir dire, please tailor your voir dire to issues relevant to your case. Oftentimes I've seen lawyers just get up and start rambling. And they discern nothing from the binary as it relates to selecting a jury that fits that case. And opening statements, resist arguing your case in opening statements. Tell the story from your perspective, but do not go legal. Develop the skill of storytelling. It is absolutely crucial to any good trial lawyer. I want to talk about objections for a minute. Be careful when making objections, in particular, speaking objections. Nothing upsets a judge more than improper objections where the lawyer begins to ramble and perhaps go into issues that were decided out of the presence of the jury. It is improper for the jury to hear certain facts that are relevant to a judge's decision on whether to allow evidence in or not, okay? If you have an objection to evidence, once that evidence is argued outside the presence of the jury and the judge tells you what the decision is, that is definitive. You indicate on the record that you object and it's noted for the record. Now, when you get back before the jury and that particular evidence is offered and the court say what says defense, all you have to say, the previously noted objection. And the judge will note that for the record, and that issue is preserved for appeal, okay? Also, I guess I want to talk about closing arguments. This is a time where you argue your case and you argue your perspective and you give the insight as to your perspective as to what you believe the facts showed. And this is a proper time to do that, okay? Time is getting away. I'm going to go ahead and turn it back over to Judge Johnson, where you can have some more thoughts, Judge.
Okay, well, I think what you just commented on was really excellent, Judge Streety, with regards to the closing statements, the opening statements, the objections, and you went into more detail than I did, but those are very applicable even on the civil side. Sometimes we have attorneys, or I have attorneys who want to go into these talking objections, and that's not appropriate. And it does open the door, if you will, to bring in something that has already been decided on. I will generally hold a motion in limine before the trial, maybe within the week before the trial. And I do that within the week. I don't do it on the day of the trial, even though we start generally around 1:30 because the jurors come in and we don't even know who they are until about 11:30, depending on what number you pull. But I will allow the parties to deal with the motion in limine a week before, because sometimes that could impact the strategy that you may have, depending on the ruling on what things I'm going to let in, what I'm not going to let in, things like that. And I want to give you a chance to adjust your strategy and how you're going to present your case. So I have finished with my presentation, and I am, available to answer any questions that anybody might have. Judge Streety?
The last thing I'll say, and I said this when I started, that people remember the first thing you say and often the last. And lawyers have to remember that they are officers of the court and they absolutely have to protect their integrity. Okay? Yes, open for questions. I guess Ms. Burrell and his staff will answer questions.
Hey, Judge, this is Chris Burrell. Let's see. We actually do have one question. Hopefully one of y'all can answer this. Looks like it's more of a probate question. The question is, may a representative of heirs in an intestacy case in probate request discovery from appointed administrator or attorney of estate? Okay, that's something either one of you can touch on.
On my face, I absolutely do not know the answer to that question, and I'll pass the ball to Johnson.
Well, I will tell you this. I'm not going to say that. I'm not going to answer that question because I don't know it specifically. I do get some probate cases when people have decided to file the case in circuit court, and I'm always back at the books because I didn't run for a probate judge, but I'm always back in the books, and I'll ask them to do a memorandum of law and I will research it. But that is something that I think will more appropriately be answered by a probate judge. So I'm sorry, I can't answer that.
All right, thank you. Okay, guys, if anyone else has any questions, you can use the Q&A function, or you can also just put them directly into the chat.
Can I just add one thing, Mr. Burrell?
Yes, sir.
While you're waiting on questions, I didn't mention this, but I want to talk about Rule 11, and that talks about a plea of not guilty by mental disease or defect and the process in going about that. And I want to remind lawyers that you failed to preserve the right to a jury determination of competency to stand trial. If your request, and when you make that request for an evaluation, is not included in the request that you want a jury to determine competency. If that is not made within your request, then you waive that right, okay? Now, if the state files a motion for a defendant to be evaluated for his competency, if you do not indicate a right to have that determined by a jury within 7 days of the state making that request, it is also waived. So I just wanted to make sure Lori's refreshed your recollection on that, because oftentimes that issue has come up and it needs to be addressed, and that I want to remind them of that, okay?
And if I could just say that my Zoom has frozen, so if there are any questions that are directed to me, Mr. Burrell, if you could, just let me know.
I don't think I know what's going on right now, but.
Okay, there is another question that has been posed.
Okay.
Are there any educational tips you would suggest for criminal or civil attorneys as a trial lawyer?
Go ahead, Judge Johnson.
Tips. Well, I cannot emphasize enough how important it is to be well-versed in the rules of evidence, because the rules of evidence are going to make or break your case. You've got to know what you can get in, what you can't. So, I mean, if there are any continuing legal education courses with regards to rules of evidence, that of course is important. I don't know, I know when I taught at Cumberland basic skills and trial advocacy, and they had like moot court kinds of things. So if there are those kinds of things, because everybody doesn't, some people, the trial experience or the trials just come naturally with them. Sometimes, it's a learning thing. So if there's anything that you can do to hone up on your evidentiary knowledge and get more practice in court, I think, that would be very, very beneficial to you as a trial attorney.
And I echo what Judge Johnson just said. I'll also add that any criminal trial lawyer should have a copy of Mitchie's Title 13. And the reason I say that is because this particular treatise, it has information in it about recent cases, and it is typically always up to date, where not only do you have the law, but you have examples of cases in this book that you can read that will guide you through the criminal justice process and help you to make good decisions in your criminal cases. So you need a Mitchie's, the Title 13, and they put out one every single year, okay? So that is a must.
Also, talk among yourselves, because you'd be surprised at how much information you probably have that is invaluable to, somebody next to you or to somebody down the hall from you, because you may have an experience that you have encountered during a trial with a judge or a witness or a juror, and you share that. And that could really be very helpful to someone else. So just keep the lines of communication open and just spend a few, maybe 30 minutes a day just talking about what you're doing and the experiences that you have, particularly if you're learning new things.
All right, thank you all. I think this is probably going to be our last question. The question is, what authority does the circuit judge have in a case where the judge has ordered a mental evaluation and defendant does not cooperate with the psychiatrist assigned to assess the defendant?
Well, and that's a great question. The circuit court judge can, in certain situations, force a defendant to submit an evaluation by committing that defendant to the Alabama Department of Mental Health. Oftentimes where the court orders that he submit himself to an examination and he's committed, of course, he's under the jurisdiction of the court, and the court can require that he submit himself to even certain medications, in particular when the defendant is a threat to himself and others, okay? So the court has that authority, and oftentimes it results in the individual being committed to the Alabama Department of Mental Health.
Thank you for that, Judge. Judge Streety, thank you so much for being here. Judge Johnson, thank you as well. We've really learned a lot. We really appreciate you guys for taking the time out to come and share with us. It is now 12 o'clock, and this is all the time we have allotted for this CLE. So I want to thank everyone for attending. Also, be sure that you submit feedback so that you can get credit with the State Bar. And lastly, if you're not a member of the Mad City Bar, or if you have not renewed your membership, please do that as soon as you possibly can. Our next CLE will begin at 2:00 p.m. and it'll be presented by, it'll be litigating 1983 cases, overcoming immunity challenges. So thanks all for being here. We're gonna break for lunch. Hope everyone has a great day if we don't see you for the rest of the CLEs. Thanks again for attending.
Thank you.
Thank you.